Hello, hi. I hope I'm audible. A very good morning to one and all present here. Thank you so much to all the panelists for joining on time. There was a slight technical error on our end. We have just now activated the panel for attendees, so they're joining. We already have some 70 attendees on board. We'll wait for a little while. So we can start in like roughly 2 minutes. 11:10 will sharp start. Thank you.
Good morning, everybody. I hope I'm audible. Right. So firstly, I begin by extending a very warm welcome to all the attendees from different law schools across India and the panelists. To just give you a brief about this panel discussion, the student community at NLSIU has closely followed all the developments related to the mediation bill, and which has now become an act. And at the very stage where the legislature body had invited comments, we had transferred the same on our part, working closely with Excuria. And now we are closely tracking developments which have transponded into an act. For anyone who could not get their hands on the primer that we had released, the Mediation Act is obviously the first ever umbrella legislation which is trying to push mediation as an alternative dispute resolution mechanism. And like there are many nuances to it, which the parliament has delved into, whether it be ancillary matters pertaining to setting up of a governance body, looking at setting up of ODR centers, so on and so forth. However, to streamline this panel discussion, we have delineated three broad issues, while also putting in a caveat that the discussion will not be limited to these three issues. To quickly go through those broad points, we'll firstly be dealing with the entry point, that is the mediability envisaged under Section 6, read with Schedule 1 of the Act, which controls not just the subject matter that can be mediated upon, but also the people who will be eligible for mediation. Next up, we'll also be delving into the aspect of what should an ideal mediation clause look like. This is especially in light of the fact that many aspects of or modalities of the mediation have been left to the mediation service provider. So we'll be discussing about what are the expectations from a mediation service provider, and as also what should the parties construct their mediation clauses like for to basically attain the desired outcome. And thirdly, we'll be dealing with the issues of pre-institution mediation. Now we have also seen a slight shift in this provision from when it was bill to now the act. And there is a contradictory stance having been taken by the legislature in both sections 5 and 7 when read together. So it will be interesting to look at these issues, especially with the deep-seated theories that lie behind them. I'll now like to hand it over to our panelist, Professor Sahana Ramesh, to start the discussion.
Yeah, hi Aditya, thank you. So a very warm welcome to everyone who's joined us today for this panel discussion on the Mediation Act. Could you just clarify for me that I'm audible, Aditya?
Yes, ma'am.
Yeah, okay, thank you. Right, so I'm Sahana Ramesh and I will be the moderator for today's session. I'm an assistant professor at the National Law School of India and I specialize in international arbitration and alternative dispute resolution generally. I think Aditya has already given a little bit on the reasons for the panel discussion taking place today. So India for the first time in September of 2023 had introduced a legislation for the regulation of mediation, a process that has traditionally been seen as an amicable way of settling disputes. The legal framework in India, as well as the attitude of disputing parties, has so far tended to be more adversarial. And so the Mediation Act is seeking to change this. And at the same time, the Act does bring about a degree of regulation that will put aspects of mediation at par with other methods of alternative dispute resolution, like arbitration, for example. So what this comes with would basically be several questions on the approach that is taken by the Act itself, as well as the need to understand and learn the best ways to adopt the new framework. So as such, the panel could not have come at a better time. And today we have some fantastic panelists with us with a breadth of expertise in the area. So I'm sure that this will benefit our entire audience today. So we have 5 exceptional panelists bringing very diverse perspectives today. So I'll just give a very brief introduction to each of them. We have Mr. Tejas Karia, who is a partner with the dispute resolution practice at Shardul Amarchand Mangaldas, and he's also the head of the law firm's arbitration practice. Mr. Karia has extensive experience with representing clients across different industry sectors in arbitration proceedings before several very famous arbitral institutions, as well as before Indian courts. So he has a very deep understanding of issues that pertain to alternative dispute resolution mechanisms, including arbitration and mediation. A very warm welcome to you, Mr. Tejas Karia. We also have Professor Sakshi Vijay, who is currently working as an associate professor at the Jindal Global University in the law school. She's a Humboldt Fellow in 2018-19 and holds a master's degree from the University of Melbourne in international dispute resolution. She has an overall experience of over 8 years, and she's a regular researcher and publisher in diverse fields of dispute resolution and law in Southeast Asia. A very warm welcome to Professor Sakshi Vijay. Also on our panel today is Mr. Tariq Khan, who's a seasoned dispute resolution practitioner and has a strong background in corporate and commercial laws. He's currently the registrar of the International Arbitration and Mediation Center in Hyderabad. And he's an arbitrator, he's an SIMC specialist mediator, and a member of the Chartered Institute of Arbitrators. A very warm welcome to you as well, sir. Further diversifying our panel today is Ms. Laila Ollapally, who is the founder of CAMP Arbitration and Mediation Practice. She has practiced as an advocate for over 30 years, but since 2014, she's been an she's been working as a full-time mediator as well. She's also the founding coordinator of the Bangalore Mediation Center, the Court Annex Mediation Program at the High Court of Karnataka, and is a senior mediator and master trainer at the Bangalore Mediation Center. She's also on the panel of mediators of the Singapore International Mediation Center, the American Arbitration Association International Center for Dispute Resolution, and other international and domestic mediation centers. A warm welcome to you, ma'am. And last but not the least, we have Mr. Ritwik Kulkarni, who is a senior associate at Ketan & Co. He regularly deals with domestic and international commercial disputes in arbitration situated in multiple jurisdictions across the world, India included. He is also the founding editor of Koinos, which is a well-known Indian blog on arbitration law. A warm welcome to you as well. So just a little bit about the structure of our panel discussion today. The panelists are invited to give their thoughts on the main issues that they believe are likely to arise from the Mediation Act's implementation and structure. These can relate to the interplay between the Mediation Act and other legislations, for example, the Commercial Courts Act, on issues like pre-litigation mediation. So India has for some time now sought to give importance to non-adversarial processes like mediation in the resolution of disputes. And so we do have a requirement for mediation um, at a pre-litigation stage. The Mediation Act also seeks to lay down some kind of rules regarding what a mediation clause should look like for it to be enforceable as the parties intended. So with a legislative recognition of mediation service providers, for example, their role in the mediation process and helping parties to achieve their goals in mediation would also be an interesting topic to have the panel's thoughts on. Additionally, the Act does seek to regulate the kind of matters that can be mediated. So the rationale, the efficacy, and the need for this might throw up some interesting discussions as well. So these are, of course, only some of the points of discussion when speaking of the new Mediation Act. There are also several others, like the lack of an enforcement mechanism in the Act for mediated settlements that have been arrived at outside of India, the extent of judicial intervention that has been envisaged by the Act, the non-incorporation of several features of the Singapore Mediation Convention as well, to which India is a signatory. So I propose that each of the panelists take about 8 to 10 minutes to share their valuable thoughts on the Mediation Act, after which I can get responses from the panelists in respect of what each of you has said. And then we can follow this up with a round of questions and answers with the audience. So I won't stand between our audience and our panelists any longer as we look forward to a very insightful round of discussion. Maybe I will invite Mr. Tejas Karia to kick off this discussion.
Thank you and for that kind introduction. And it's such a pleasure to be with you all on a Sunday morning just before the ICC World Cup final. So I'm sure all of us are excited for that and all ready for it. But coming back to the topic today, the mediation, which is very, very important subject as you just mentioned, because of the need to kind of give an avenue to the parties to resolve their disputes other than the traditional litigation mode and the arbitration, which has become very popular over a period of time to resolve the dispute. The nature of dispute resolution through mediation is quite different than the adversarial dispute resolution mechanism. And over a period of time, we have seen a growth of mediation in India, and with the Mediation Act coming in this year, it's going to achieve the desired, expected level of giving mediation a due recognition to resolve the disputes. In India, we have more than 450 centers who is providing mediation services. We have around 17,000 mediators and growing every year. But what we need is also capacity building and trying to get more and more parties aware about the benefits of mediation, having a trained mediators. And I'm sure various provisions of the Mediation Act is going to really help us to achieve that goal. We have quite a few stakeholders already having a buy-in in terms of the industry, in terms of the judicial system, who have really supported the alternative dispute resolution mechanisms. We see our courts are also supporting the entire movement towards moving towards the mediation and trying to make it very popular way of resolving dispute. We have all seen, even in arbitration, we have had experience of having the benefits of mediation, because what happens is that parties really don't want to fight all the way, because if they know the weaknesses of their case, and the mediation gives a win-win solution for both parties and also continuing relationship in terms of the commercial ventures. So ultimately what happens is that the mediation provides an avenue which is not possible through litigation or arbitration. And that's why we thought of having mediation as a precursor to the litigation. So the original idea was to have a compulsory mediation before anybody goes to the court or arbitration. But the standing committee of the parliament, where I also represented CII and made some presentation, the view was that by nature, the mediation is a voluntary process, and therefore the original section 6 was there in the bill of 2021 was then modified to make it voluntary process by consent of both parties, with an exception that if it is a commercial suit under the Commercial Courts Act, Section 12A of the Commercial Court Act will have an overriding effect. So there is a proviso on Section 5 itself. The new Section 5 makes it, the existing Section 5 of the Act as enacted makes it a completely voluntary process. There are advantages and disadvantages both. The advantages are that unless parties have a buy-in into the whole process of mediation, is not going to be successful. So no point forcing a party to go for a mediation ultimately when they are not going to agree. It's just a time which is spent without believing into it. The other way to think about it is that parties don't realize the value of mediation unless they go into the process, and therefore pushing them or nudging them towards the mediation is going to help them. And if they don't like it anyways, they can come back to the litigation. So there were divergent views on the compulsory nature of the mediation. As of now, we have adopted a voluntary approach, which in my view, we can see how it goes, because there is also Section 7, which again gives power to the court to kind of nudge the parties towards mediation at any stage, and also protect the parties by giving interim measures if it is required to protect the subject matter of the dispute. And I don't see there is any, subject to the views from my colleagues on the panel, there is a big divergent or a contradiction between Section 5 and Section 7, because both of them, they operate in different spheres. One is irrespective of the mediation agreement, you can parties can agree for a mediation. They can go for the mediation and then try to resolve it. If not, they think they can follow their legal rights in terms of either the arbitration or litigation. In Section 7, when you already have a court matter, then the court can, or the judicial authority can refer the parties, encourage the parties to do so. This is very helpful because we have existing legislations like in CPC, Section 89 is there. There is Consumer Protection Act. There are various other legislation which refer the parties to mediation, and Section 7 really helps us to move towards that particular aspect. As far as enforcement of mediation clauses is concerned, it's not there in the Act, but there are several cases, the case laws which have developed even prior to the Mediation Act coming into force, which has recognized that multi-tiered dispute resolution clauses, where you start with the less formal dispute resolution mechanism like mediation or a conciliation or a good faith negotiation, and then move towards more formal, the more formal way of resolving dispute is the arbitration. Many of the high courts have refused to appoint the arbitrator if there is a mediation agreement in the dispute resolution clause, and said it's a premature and the parties should go through the process. Many times we have filed Section 16 application before the arbitral tribunals, challenging the jurisdiction of the tribunal, saying that unless the parties have followed the compulsory mediation, then only they can invoke the arbitration, and the arbitral tribunal does not have jurisdiction to decide these cases. Some high courts have taken a different view, saying that if the clause itself or the correspondence between the parties itself shows that there is no way the parties could have resolved the dispute, or it would have been a futility to force party to go for mediation, then they can bypass that provision and go to the arbitration straight away. So there is no consensus on this approach. The courts have taken views based on the facts and case-by-case basis. Any provision for or a recognition of a mediation clause to be enforced prior to starting the litigation, if the parties have agreed for, would have helped if it would have been introduced in the in the Mediation Act. But nonetheless, there are case laws, so the parties can always rely upon them if they feel that the mediation agreement was not given effect to. As far as the Singapore Convention is concerned, we are signatory to the Singapore Convention. I was present at the time of the signing ceremony, but we have yet to ratify it. In the previous versions, we had a chapter on Singapore Convention, and we were very hopeful that by the time the Mediation Act comes, we would have ratified the Singapore Convention. But as and when we do so, we should incorporate that into our act, like we have New York Convention incorporated in Part 2 of our Arbitration Act. Drafting a mediation clause is an art. There is no formula or a recipe for a model mediation clause. The best way is to go for an institutional mediation. We have experts on the panel who will talk more about the institutional mediation. But generally, to talk about the ingredients of a good mediation clause, that would include the confidentiality of the processes. What are the trigger points for mediation process? Who can invoke mediation? Duration, timelines of mediation has to be specifically written. If there are rules of mediation in institution which parties would like to incorporate by way of a reference, parties should make it clear. The place of mediation, it has to be decided, and ideally it should be neutral. An appointment or a choice of a mediator, either you leave it to the institution or provide how the parties would go and appoint a mediator, and also allocation of cost. If the mediation is unsuccessful, who will bear the cost of this mediation? So these are the broad parameters on the basis of which the parties can draft the mediation clause, and also just by naming it as a mediation clause or mediation agreement does not mean unless the ingredients of that is there. So we have a case of Consolidated Construction Consortium versus Municipal Corporation of South Delhi, where an arbitration clause was termed as a mediation clause. And the court said it was nothing but an arbitration clause because the nomenclature doesn't matter. You have to see the substance of the mediation. As far as nature of the disputes which can be mediated, we have a list of disputes which cannot be referred to mediation, which brings in a lot of clarity. We will discuss as we go along during this panel discussion what kind of disputes cannot be mediated. And also there are certain classes of people. For example, the first exception is that the minors or deities, persons with intellectual disabilities, are excluded from the process of mediation because of their intellectual incapability to understand the benefits or the process of mediation. And there is nothing wrong with it. That's my view, that that is what the law has recognized, that they don't have any ability to understand the process, and that's why they should not be referred to mediation. But if minors are there, it could have been that the legal guardian or the parents can represent them, or anybody who is representing a deity can be sued. Then why not the trustees can represent the trust? But again, the question comes up of not impacting third parties, and what we have laid down in the case of Vidya Drolia in terms of the arbitrability of the dispute, having now clarity that whether it's right in personam or right in rem, which has to be looked into before deciding the arbitrability of the dispute, which has now incorporated in the Mediation Act itself, which says that if they affect the rights of a third party who is not a party to the mediation proceedings, except of course to the matrimonial disputes where the children are involved, those are not capable of being referred to mediation. So yes, definitely the third party's rights have to be protected and seen that they are not impacted if the rights are in rem, impacts the larger interest of public at large. And if the disputes are such that it cannot be decided between the parties inter se without impacting the rights of third parties, then of course mediation cannot be the best suited mechanism for resolving such dispute, because ultimately enforceability would be an issue. So that is we have seen so far. These are the issues I feel there in the act. But overall, it's a very progressive step in towards mediation, and it will bring India in forefront of the scheme of the mediation across the globe, because we are also recognizing the international mediation. If it's seated in India, then it will be enforceable as if it's a decree of the court, which brings a lot of confidence in the investors who want to invest in India, that mediation is an avenue to resolve the dispute, which is now having a legislative recognition in India. Thank you.
Thank you, Mr. Karia, for that enlightening and very comprehensive comment on the Mediation Act. I won't really pause for questions now, but I think that there has been a fair amount of highlighting in respect of the degree of formalization that we are now seeing in the legislation as compared to previously. And I think you make very good points in respect of how having another dispute settlement mechanism apart from what we already have might be a confidence booster for investors as well. Maybe we will now move from practice to academia, and I'll have Professor Sakshi Vijay and her comments on this, as well as any other issues that she's identified.
Thank you so much. Thank you. I'm just checking if I'm audible.
Yeah.
Thank you. Okay, so Tejas sir is actually my senior from ILS, and it's tough to follow after him. He's so succinctly given a primer about the entire act, especially the elephant in the room, which is the mandatory or directory nature of mediation in general. So for that, I'm just going to give a little more optimistic reading of how I've seen the situation. And again, I'm following a lot from what I read and what Laila Ollapally ma'am keeps speaking in her webinar. So I'm giving a caveat that I've borrowed a lot of my understanding from what she keeps writing and telling. So basically where we stand today is we have a Commercial Courts Act, which is saying that there has to be compulsory pre-litigation mediation. And then we had a bill, which like Tejas sir said, spoke about compulsory pre-litigation mediation. The difference being that there was no exception to the urgent interim relief, which is there in the Commercial Courts Act. But the mediation bill also had something related to at least 2 seatings have to be there, which again comes perhaps from the understanding, which again Tejas sir mentioned, that, you know, the proof is in the pudding. Unless you have the parties sit across the table with a skilled mediator, they'll never find out. So perhaps that minimum 2 seatings sessions arrangement came from that thinking. Well, that has in the final act not actually been replaced by a directory mediation provision, which is section 5. So right now where we stand is we have the most mediations which are happening are actually coming from the court, which is under section 89. So that stands as it is. And why mend something which is not broken? So even the act has sort of walked across the court-referred mediations and have them going on as it is. So that is going on as it is, but there is a compulsory pre-litigation mediation in the Commercial Courts Act that is functional right now. But again, the controversy there, which I'm sure as we go further, and my colleague Ritwik, who's also from ILS, will also probably focus on how, you know, in practice, this functions and how people try to segue around it or bypass it. So that, and this is again, I'm borrowing from Laila ma'am, that, you know, we need a critical mass of satisfied users. So perhaps we are having that from the court annexed mediation centers, and also because we are having compulsory pre-litigation mediation through Commercial Courts Act. Now, the background of this, perhaps it was not seen prudent, maybe because of there's no capacity right now to have compulsory pre-litigation mediation also in the act, in the Mediation Act. So I see it as a phased sort of a running towards a situation where people have their perspective changed about mediation. That's the final objective, that when we think about disputes today, in our common culture, it is always that resolution happens through court. Now, a little bit of that changed through arbitration, but that again is a rich man's business, sort of. So, to change that, we do require around 30-40 years of investment into the idea of non-adversarial or consensual dispute resolution. And the first step for that, perhaps, is to have a little bit of compulsory pre-litigation mediation, but overall to tell people that if you want, you buy into the process. Now, a small problem there, and I highlight this because it's already there in the Companies Act, in the Consumer Protection Act, in MSME, in in various statutes. This directory nature of mediation already exists. The problem is what we call the first eye blinker syndrome, which is the party that suggests mediation is often perceived as the weaker party, which is scared to go to court. And this is why parties, even though they believe perhaps in the process of mediation, or are at least reluctant to go to court through the ordeal of litigation, are still not very comfortable giving the idea of mediation. Now, perhaps the panelists here who are dealing with clients in commercial matters can tell us how a lawyer plays the role there, because they'll be better placed for us to understand this. But at least from the party's perspective, it is taken as a weak man's or a weak person's outcome. So that is, I think, a problem with the bill right now, with the act right now, because that is not being addressed. Now, another reason why I say this is in a phased manner is because of the notification of, this was, I think, 7th October, that only the Mediation Council of India and the Mediation Fund has been notified. So even as we speak today, we don't have any other provisions of the Mediation Act functional except for the Mediation Council and the Mediation Act. Now, why is that? The logical conclusion perhaps is that once we have the infrastructure in place, that is when we want to open the doors of mediation to users. Because, mediation is only as good as the mediator. If we don't have the mediator human resource ready, which Sir said there's 17,000 mediators right now, a good number. But again, is it enough for the enormous amount of disputes that we are facing today? And who are these 17,000 mediators? Have they, there's no professional regulation as such, which the NCI plans to do. So that is again something that makes me think that this is going to happen in a phased manner. And eventually most matters, like it is in the US today, will be, mediation will be taken as a default first mechanism before any adversarial methods. So that was just the point I wanted to make, because that's already explained by Tejas sir. And now coming to section 6, which is, I call it the blacklist. Now we see that the Arbitration Act did not take the blacklist method. It left it open to the judiciary to decide whether a matter is arbitrable or not. Now this same method could have been adopted by the Mediation Act. Perhaps it's not, because we saw what happened with the Arbitration Act. There's too much inconsistency in the jurisprudence that we hold today. And you've taught ADR, so we know how to deal with that enormous mass of diversification that, and we have to make sense out of it. So maybe that's why it's a good thing that this list is already provided. Now, my optimism fails me in some places in this list. And I am with Sir where it talks about the right of people, that is point number 2 in Schedule 1, which is people with disability. And I agree with Sir that the differentiation or the discrimination comes from CPC itself. And it's not as problematic, relatively speaking, as perhaps point number 4 and point number 7. And if you'll just allow me to elaborate on point number 4, which I think is the most problematic point. Especially because the entire jurisprudence comes from right in rem versus right in personam. And point number 4 talks about a situation where a professional, and let me give my example. Suppose I'm a mediator recognized by the Mediation Council of India, and I have a dispute against the professional body, which is the Mediation Council of India. My dispute is barred from being mediated under the Act, according to point number 4 in Schedule 1. Now, this is such an irony that a person who is a mediator cannot have the dispute resolved. And a perfect, at least how I see it, subject to correction by my panelists here, is a purely right in personam sort of a situation. Person A against the professional body. Same goes for CAs, CS, medical practitioners, press people, and these are bigger problems. Why did we have to put it in the blacklist? Similarly, tax disputes, which is point number 7, and I'm sure this was debated in the standing committee, which Tejas sir also was giving evidence to. And the tax department itself has advertisements about how they should do dispute resolution through consensual methods, which is like, just give you an example, the DRS Scheme Finance Act of 2021. So they themselves are promoting it. And it becomes very confusing for a common man to at one hand see that there is promotion about mediation in tax matters. On the other hand, you put it in the Schedule 1. So again, Schedule 1 is problematic, but then the silver lining, so to say, is that the schedule will be amended by the central government as and when the time comes. So perhaps this is again because we want to do it in a phased way. The more controversial matters will perhaps, once we have a substantial mass of satisfied users, once we have a infrastructure developed enough, the mediators are regulated enough, maybe then these matters can be made to be mediated. So that was just my take on Section 7. I agree with Sir in Section 5 versus Section 7. I don't think there's any controversy. It's just that Section 7 is a reinforcement that even if you failed mediation pre-litigation, the court can still ask you to go and try mediation, which is I think a good thing, because your situation has changed, and I think once some amount of litigation fatigue sets into the participants, they are more pro to do a mediation between them. They might have a different experience from pre-litigation. Now, I think Sir has spoken about the Commercial Courts Act. And again, there was a case that was mentioned, which I think is a good decision by the Supreme Court, which is the Yamini Manohar versus TKD Keerth, which talks about how interim relief. Now, again, this is about not the Mediation Act, but the Section 12 of the Commercial Courts Act, which talks about urgent interim relief being an exception. In that case, you don't have to go through compulsory pre-litigation mediation. Now, at least I don't know in my limited practice of any interim relief which is not urgent. So by nature, and that's not even defined. So every party or every disputant litigant who wants to bypass this can simply ask for an interim relief. To how to differentiate between what is real and what could be just frivolous will again require judicial scrutiny, and that is again waste of court's time. Instead, I would support the situation which was presented in the Mediation Bill of 2021, I'm sorry, which said parallelly you can have a standalone interim application going on in court, which is the way it happens in arbitration, and parallelly have your mediation going on. Right, the two won't affect each other, and of course, the objective of both the matters is different. Here, you're trying to maintain status quo, whereas here you're trying to resolve your dispute overall. So that was just my take on interim relief. Now, about agreement to mediate, Sir has given us some practical tips. I also feel like the arbitral institutions have their own ready-made, these clauses which can be adopted. So will mediation service providers, and CAMP actually does have a mediation clause which can be adopted. So that is something that can organically function. The only thing I can add is for parties to have a deadline of how long the mediations should happen. Which I'm sure MSPs have, but for ad hoc mediations and even for negotiations for that matter, that becomes problematic then for the courts to function. And I just want to add something here, I just want to add something here about the return of investment of bypassing a mediation clause is not as much as that of an arbitration agreement. The kind of energy parties put into bypass an arbitration agreement is obviously much higher, because otherwise you're stuck with that forum. Whereas in mediation, the worst thing that can happen if I'm a party who does not want to comply with the mediation clause is I'll have to sit through 2 boring meetings. That's the worst case scenario for me. Is it worth going to court for, not for evading these 2 sessions is the question. So I don't think this will become as big a question of interpretation as arbitral clauses are. However, it's an important thing to discuss. And I think I'm left with 2 points, one about international mediation and Sir said this, that the previous bill had a chapter which was exactly the format that the Arbitration Act has, which is a separate chapter on Singapore Convention, which would have been, I think, a simpler way to deal with it. But notwithstanding that, the current act does give enforcement teeth to parties where one party is from India. So if the situation is there's one party from India and a foreign party, and they have a mediated settlement agreement, the Mediation Act does apply to it, and enforcement will be as if it's a decree of a court here in India. But this does not apply if the two parties are international. For example, there's a Nigerian and an Australian party, and they want to enforce their mediated settlement agreement in India. Then the current Mediation Act does not allow for it, whereas the Singapore Convention did. So the ratification has not happened, and it would have been simpler to have a chapter here. Perhaps the last point I want to make is about Schedule 2. Actually, there are two more points which were mentioned. One was about role and reliance on MSPs. Now, mediation service providers are going to be like arbitration institutions, and they will play a very important key role in determining the future of mediation in India, the quality of mediation in India. And I think Laila ma'am is an expert because she's built an institution like that, which is a private institution in India. I don't think the reliance on it is too much, but of course, regulation will be required by the Mediation Council of India, and I'm fairly optimistic about this. And the last point is about Schedule 2, where absolutely my optimism fails me. I don't see why, for example, the Families Court Act had to be overriding the Mediation Act. The Family Courts Act, for example, talks about conciliators trying to resolve the situation and how judges and the entire family court infrastructure is pushed towards settlement. Now, that in itself could be guided or regulated by the Mediation Act. I don't see how the two would have, why there was a requirement for it to be not governed by the Mediation Act. The Mediation Act is only providing an infrastructure for the conciliation, which is mandated, sort of recommended by the Family Courts Act. Similarly, they even other acts such as the Industrial Relations Code is overriding the Mediation Act. Now, the problem with the Industrial Relations Code, or even say the Industrial Disputes Act, which talks about conciliation, is their conciliators are actually biased towards one party, right? Which is not pure conciliation or mediation. So, in fact, these are the problematic sections which could have be guided better if the Mediation Act was overriding. So that's it. I hope I have, just covered every bit of what we thought we'll discuss. And I'll just hand over to the other panelists. Thank you so much.
Thank you so much, Sakshi. So I found it really interesting that you were drawing references to other legislations and looking at how the Mediation Act will itself play out when those legislations exist. But there was something that both you as well as Mr. Tejas had brought out, and which perhaps the panelists who will be coming up with their thoughts might also want to reflect on, the question of how it doesn't matter if you have an act that provides for mediation. It doesn't matter if pre-litigation mediation is made compulsory if parties are basically going to either just do it just because they had to do it, or they try to bypass it. So something that both of you so far had spoken of was in terms of capacity building and trying to change the perspective of parties in relation to mediation. And while I think Sakshi had mentioned that this might be a work in progress and the Mediation Act is a good first step, something that I would like to also throw open to the panelists who will be coming up is how do we actually take this step a little forward so that parties start taking mediation as a serious alternative dispute resolution mechanism where perhaps they can actually see whether the dispute can be finally resolved, instead of just using it as a step to go to another adversarial mechanism. So maybe I can have Ms. Laila Ollapally with her thoughts before we proceed with everyone else.
Thank you very much for having me here. It's always inspiring to work with a law school because I feel a lot of the thinking, deliberation comes from there. So thank you very much. And after what Tejas and Sakshi said, I wonder if there's much more that I have to say. But maybe let me be a spoke in the wheel. I will go to mediatability, pre-institution mediation, the aspects that are not covered, mediation clause 12A. Having been a part of the committee constituted by the Supreme Court to make recommendations for a bill, and also part of the committee constituted by the government to set up standards, I go back to the thinking that happened. And yes, I feel when I look at Schedule 1, we have responded because we really have not understood that mediation is negotiation. How much do you want to curb negotiation? I would say, okay, it's acceptable. Criminal offenses and where third-party rights are impacted and the third party is not present. Having said that, Supreme Court referred a criminal case 307, attempt to murder. In its wisdom, Supreme Court understood what the consequences would be to send this into the adversarial system. It came in for mediation. We resolved it, and the family is now living happily. But I would still respect the fact, criminal offenses, yes. But I want to briefly go into each of the others. Let's look at claims against minors, persons with disability, high support needs, persons with mental illness. There is a legislation that is so specifically, there are legislations that are specifically catering to their decision-making needs. Joint decision-making, guardianship, advance directive. These are fairly sophisticated. Sometimes I think, what if Stephen Hawking could not mediate? Are we suggesting something like that? What about claims against professionals with statutory authorities, doctors, lawyers, as Sakshi so beautifully mentioned? Have we forgotten the instructive value of mediation? Doctors are human beings, mediators, lawyers, professionals. We make mistakes. And sometimes what the affected party wants more than anything else is a conversation. What does the adversarial process do? The moment there is a complaint, the professional goes behind those. Where is that conversation? And we know that mediation has no prejudice to any trial that may follow. An interesting example of a party who was hurt by a surgery came in for mediation. She was rich. She didn't need the money. What she needed was that this should not happen to anybody else. In the mediation, one of the terms was that the doctor would go for additional training on that procedure. This is the instructive value of mediation. Organizations learn how to run their organizations better when the feedback is through a mediation. So I feel we should provide for mediation in section 4, clause 4. Clause 6, National Green Tribunal. We are overlooking the fact that mediation provides for multi-party disputes. I have mediated with 60 parties, and the voice of all 60 was heard. When compensation is being thought about, when relocation is being thought about, mediation is the process where the voices of the multitudes can be heard. Why are we taking that away? In many parts of the world, important environmental decisions are taken by bringing all the stakeholders into the mediation, the regulatory authorities, the affected parties, everybody comes in for the mediation. All their voices are heard. Mediation is specifically designed to bring in the voices. And there is a there is a very good way the mediation movement has developed, and it's called consensus building. There are very eminent, Leonard Ruskin and others have developed this concept of consensus building. Are we shutting our doors to that? Again, tax, US, UK, and we ourselves have these settlement commissions. What about, what's the next one? Okay, Telecom, Competition Act. This is an opportunity to bring the CEOs, the regulatory authorities, everybody onto the table. Work with them so that the business is not impacted, competition is not impacted. Look at creative solutions. Apple, Amazon, Microsoft. Their very important antitrust disputes are often mediated. Why are we losing these opportunities? Securities and Exchange Board, we already have an ODR mechanism. I sat in for a mediation of the biggest bankruptcy case in the history of America. It was mediated. When Sri Lanka was hit by tsunami, they had a tsunami board. Lehman Brothers, arbitration and mediation was immediately brought in when the collapse happened. And 78% who opted for mediation, the remaining for arbitration. And there was an 88% settlement. So, with great respect, I would like to say that I am not comfortable with Schedule 1. It has taken a narrow view of mediation. It is almost nipping the bud of mediation before it took off. Definitely, capacity has to be built. And in India, we definitely have capacity, provided we do not look at mediation as free service. If young people like each one of you can make a living with mediation, creative people, smart people who have the ability are nurtured to do mediations, each of these cases can be mediated. That is as far as mediatability is concerned. Then I go to, of course, Schedule 2, Family Courts Act, sexual harassment. Why can there be no mediation when the guide for sexual harassment cases, when the guidelines for the Ministry of Women and Child Welfare provides for informal dispute resolution? And that should come under the Mediation Act. A large number of the sexual harassment cases are not captured because people do not want ICC and they are seeking a safe space where they can talk. They're seeking a space like the mediation table. The ICC members are mostly from the organization, and they are not the people who mediate in the manner that confidentiality is so sacred. Similarly, I would say in the welfare of parents, this is where you should nurture relationship. The conciliation officer is somebody appointed by the government. Can that person nurture relationship, build communication and nurture relationship? Why are we losing those opportunities? Then I come to pre-institution mediation. I think Tejas and Sakshi have covered a lot of it. I just want to highlight that there is the opt-in model and the EC opt-out model. We seem to have gone in for the opt-in model. Now, mediation is a disruptive innovation. Why do I say it's a disruptive innovation? Often parties are not in a mood to mediate when there is conflict. Lawyers are not in a mood to bring it into mediation. So we have to change. It has to come organically. The mindset has to change. And how do you do that? By giving them a good experience of mediation. As Sakshi said, critical mass is then developed. They become the ambassadors for mediation. And that is why, keeping that in mind, we have the EC opt-out model. That is, the process step is mediation. But it's very easy for them to opt out. And this comes from a concept in behavioral science. There is this famous case of organ donation. Research was done where countries like India, US, UK said, opt in. If you want to donate organ, opt in. Very few people donated their organs. But some countries like Brazil, Austria, and some others, they said the policy is organ donation. But anybody, any family member, the person concerned, anybody can opt out at any point of time. And you know what? The human behavior prefers status quo. So they don't go out of the way to opt out. So the EC opt-out worked much better. And that's why I feel those 2 information sessions, which is only helping parties build their willingness. It is actually bringing the parties in authenticity, taking away all the layers of posturing that they otherwise do and bring them into mediation. And if we have capacity, if there are good mediators, I can assure you 60 to 70% can be converted into voluntary mediation. And I'm depending on the AFCON's judgment, Supreme Court AFCON's judgment, which says referring to mediation is not in violation of voluntariness of mediation. It is only forcing them to participate that is in violation of the voluntariness of mediation. So that's my perspective on that. And then on mediation clause, I was happy with section 4 until I saw section 4.5, which said parties with all that, I mean, they brought it out so well. Intention, it's, you know, the whole concept of arbitrability is not really relevant for a negotiation. It's only the intention that matters. So it was fine until it came to section 4.5, and then they said with all that, parties may submit to mediation. So I really can't understand. The components of a mediation clause, I think they just beautifully covered it. It's okay. And then section 12A, yes, Yamini Manohar, I totally approve of that. And I only wish that 12A had a clause which said something like section 7, which said if urgent relief is granted, okay, get your relief, come back and go back into mediation. That should have been added on to it. Then regarding enforceability of mediations conducted in India, conducted outside India, yes, it becomes a domestic mediation, or this act applies. Section 13 does not have, temporal jurisdiction, but parties can agree to mediate anywhere else. So we can bring it under the domestic mediation, but definitely now US, UK, most countries are going in for ratification. Just yesterday, I read an article where US, a committee has been constituted and they are going in for ratification shortly. India should also go in for ratification. Regarding service providers, yes, we have an important responsibility. As Sakshi mentioned, it's only the quality of mediation that will sell mediation, because remember, this is voluntary self-determination. So mediation service providers have a very important responsibility to have a good panel of mediators, to have the rules, to maintain quality. These are my thoughts. Thank you.
Thank you, ma'am. That was a very comprehensive discussion on the various mediability points on Schedule 1. In Schedule 1, one of the things that struck me was, I think, your opinion that there are a lot of things that we might find in the arbitration context which don't necessarily find a place in the mediation context, but which have somehow made their way into the Mediation Act. So specifically, what I would ask you, maybe once we have everyone's opinion, but also maybe the people who are coming after you can also reflect on this, is the degree of formalization that has brought it quite close to arbitration in many respects, including the comparison between arbitrability of disputes and now mediability of disputes, as well as some kind of guideline in relation to the intention to mediate having to come out in the mediation clause, things like that. Is this level of formality required at all in mediation, or is it just that the Mediation Act should have aimed to push parties towards mediation, but leaving things more in their hands? I'll come back, ma'am, to you with this, but let me just get the opinions of both Mr. Tariq as well as Mr. Ritwik. So maybe we can start with Mr. Tariq and then I'll move to Mr. Ritwik.
Thank you, Sahana. Thank you very much. It was indeed a pleasure to listen to Tejas sir and Laila ma'am. They covered pretty much everything. And the other experts, I'm the one who probably is the least informed about mediation. But I had few thoughts to share as an institution and as a service provider, because Ms. Ollapally very rightly said that a lot will depend on the quality of service that is being provided and the mediators that are there. But I also would like to add that success of mediation largely depends upon the commitment and interest which is shown by the respective high courts, and also the commitment and expertise of the mediators. And the Act is a very positive move, like Mr. Karia rightly said, because it is moving towards institutionalization of mediation and also aiming at grading mediators and institutions so that the quality gets better. But I think that there is a need for a continuous education of lawyers and legal professionals, litigants and judges, by undertaking several programs, because that will assist in increasing the use of mediation as a process for a resolution of disputes. Now, I was reading the aim and objective of the mediation law, and the Act says that the idea is to make India a hub of mediation. Now, what is it that is required to become a hub of mediation? I think that the most important part is a legal framework, which was missing for the longest time. But now, fortunately, we have the Act of 2023. But the Act needs to be robust, that supports mediation. And there also needs to be an ecosystem around it which supports mediation. Now, the legislation has been enacted. There have been a couple of, hits and misses. There are some things which are, highly appreciative. I mean, people have been saying great things, but there are a couple of things which could have been considered but have not been considered. I think the panel has already delved into that. One suggestion I think where we are missing still, and we still have an opportunity, is ratification of the Singapore Convention on Mediation. I think that will send a very positive response message in the international community, and will be able to help us with the issue of enforcement cross-border. The other thing I feel which is very necessary and which we need to work towards is also the implementation. because the law pretty much is adequate. Same thing happened with arbitration. I don't think, and I hope that mediation will not go the arbitration way. I was reading the act and I was seeing pretty much many provisions are on the same lines as the Arbitration Act. And like Ms. Ollapally rightly mentioned, many things are there which may not have been necessary for the Mediation Act. But I think there is also a need to establish state-of-the-art mediation infrastructure to take it seriously. I understand that infrastructure is not the most important aspect, but still I think that mediation centers should have modern facilities and technology, especially when the act is talking about the online mediation. And unless we really have the technology and modern facilities, I think we'll not be able to achieve that objective. And these centers and the service providers should easily be accessible and well equipped to handle even international disputes and online disputes. Now, there was a brief discussion about professional trainings, that we need quality mediators, we need service providers to be offering good quality service. So I think there is also a need for comprehensive quality training programs for mediators, because I think there is a lot of potential. We do have a lot of quality mediators, but still I don't think we have enough to handle the demand which is going to be there in times to come. So I think there's a great potential for skilled and internationally recognized professionals. I think that will be really, really crucial if we would like to become a hub of international mediation. The other thing that I would like to say is that certification process. I hope the Mediation Council of India and the service providers are able to really regulate and control the quality, because it's very unfortunate that many centers or institutions or individuals have been offering mediation trainings who otherwise have not been trained themselves, and they have never really undergone any training. So that is, and a lot of people are also doing commercial exploitation. I think that should stop. There should be some regulation, some mechanisms, some guidelines to ensure that the quality of mediators is good, because success of the act also will depend largely on who's the mediator. And I give you an example. Suppose I do a mediation and the mediator was not a trained mediator, and I was not very happy with the overall experience, then maybe the whole impression of mediation will change for me, and that is the image that I will carry forward. The other thing I feel which is very important to create an ecosystem is international collaboration and adopting the best practices which are there internationally. So I think there is a need to get the best practices by engaging with organizations which are doing very well and which have a proven track record of doing good mediation. I know many people may not find it important, but I think marketing and promotion is equally important. Internationally, people must know what India is doing in mediation. What is it that the centers and institutions have been achieving? What is their vision? I think that is equally important. We need a government support. So every state must support these service providers. I think that will be very crucial. And case management also needs to be of high quality. I think I urge students and aspiring lawyers to consider choosing a career in institutional arbitration and mediation, because I think that's where we may not have a lot of good resources. We need good case managers, and that will only happen when people and legal professionals start looking at it as a career option. There's another thing I wanted to say, that unless and until this society attains the maturity and wisdom to sort out its disputes through alternative mechanisms such as mediation, I think judges will have to play a very crucial role, an important role in developing mediation by referring litigants to such processes, by exercising their power under the new law. Of course, Section 7 is there, Section 89 of CPC. But many judges are of the view that they should concentrate only on decision making, that is adjudication. And for some reason, some of them have a feeling that we do not want to spend our time and energy in persuading litigants to have recourse to arbitration or mediation. Now, when a judge is himself not convinced that the mediation process would provide an effective remedy, then the entire effort to refer the parties to an effective ADR process would be casual and making the whole referral a mere formality. Now, I think it's equally important that Judicial Academy should also focus on doing trainings for all judges mandatorily and from time to time, not just once in a lifetime. I think unless we train our judges, role of referral judges, what is it that they can do to build the mediation ecosystem? I think law in itself would not be enough. I think, without the implementation, we will really lose focus. And the rule is simple that, the less number of cases being referred, the lesser will be the success of the mediation process. And duty of the government should also be that, because state is the largest litigant in the country, I think if it becomes a responsible litigant and do litigation only when it is necessary, I think the burdens naturally would be reduced tremendously. But even if it plans on going to the court, I think state must encourage referring matters to mediation. So all in all, to sum up, I think there are certain challenges to overcome. It is a very positive step, but I think the awareness is largely missing, especially in the business community. The real stakeholders do not really know about the benefits and process of mediation. Enforceability of settlement, like I rightly said, is an issue at the moment because, especially because the ratification of the convention has not been done. Quality of mediation training will be crucial in deciding the success of the act. And court annex mediation centers have been given too much emphasis, but I'm not really sure about the performance of, there are some states which are doing really well. I think Bangalore, Delhi have been doing a great job, but I don't think same is true for every state high court annex centers. So I think court annex mediation centers, we really need to look and do something about it to improve the quality of the mediation being offered. Infrastructure has to be improved. And lastly, I think lawyers will also play a very important role. So programs for lawyers should be done because they should not look at it as a drop in the revenue. They should look at it as a mechanism which will really not take away their work. So these are some thoughts which I wanted to share. I'm sorry I exceeded my time, but I thought these are something which would be relevant. Thank you.
Thank you, Mr. Tariq. I think you made some very important points in respect of the implementation of the legislation itself, as well as certain things in relation to how different stakeholders can make the mediation ecosystem better. Before we head to Mr. Ritwik, I just had one question for Mr. Tariq. You had mentioned that best practices across the world should be adopted here as well. As someone who works with an institution that is looking to make mediation a more mainstream dispute resolution mechanism, what might these best practices look like for institutions in building this ecosystem?
I think to give you an example, if you look at Singapore, I think Singapore is the best example I can give for international best practices on mediation. We signed an MOU with them recently, and we in fact did a training with them here. And I think Laila ma'am will also tell you she was here with a group of people from FSRL and Harvard negotiation program. So at IMC, we have never compromised on the quality of the trainings and programs. We recently conducted with Laila ma'am a mediation advocacy. So that I think is a best practice because in India, there was dearth of trainings on advocacy in mediation. People have been only focusing on mediators training. So I think that's one example. The other is, if you look at protocols like ARB, MED-ARB, LIT, MED-LIT is the recent one. These are emerging best practices, but in India, there is no discussion about it. So we bring people from the outside to talk about it. We inculcate that in our rules and also making your rules more modern. For example, the role of ODR, having ODR in itself is not enough, but there also should be protocols for data privacy, for discussion. There is risk when you're going too much into the technology. You also need to ensure the platforms you are using, there should be some guidelines, end-to-end encryption should be there. Now, these are all best practices. So for that reason, we also did a co-mediation protocol that if there is an international dispute, parties sometimes may prefer having two institutions instead of one domestic and one international. So that's also a practice which IMC at least has inculcated, that we give an option to a party because they may not want to use only a domestic center. So they also want an international institution to be involved. So IMC and SIMC are also doing a co-mediation protocol, for example. There are many other best practices. I'm sure Tejas sir and Laila ma'am will be in a better position to tell you, but these are some things I could think of.
Thank you so much. I have a few more questions, but I think I'll come back after Mr. Ritwik speaks as well. Yeah.
Yeah, thanks, Sahana, and thank you so much for the earlier panelists, including my seniors from ILS. Very insightful, and I think a lot of almost everything about the Mediation Act has already been covered. So I'll very briefly cover a few thoughts that I have, and then I'll hand it over back to the other panelists. So I think. So I'll just take a step back. I feel like on a fundamental level, they say that two things in life are certain: death and taxes. I would add a third: disputes, because where there is an opinion, and we by our nature we tend to have opinions. Where there is an opinion, there will be a difference. So our differences and therefore disputes. So dispute resolution becomes a fundamental aspect of social interaction as well as policy, because it is so integral to our coexistence in society that the state must have some kind of thought about how disputes must be resolved, especially in a democracy. So I want to look at the Mediation Act from a policy perspective, and what the policy that it, I think, addresses is the management of justice. So within that concept, I would think that there are three key stakeholders in the justice management system of a state. The first is, of course, the litigant. The second is the judiciary or the courts. And the third is the public at large. Now, from the litigant's perspective, I think the concept of mediation or settling is not that new as such. It's been said a lot of times that it's actually a part of Indian ethos and culture, which is true. Now, I think what is also happening from a litigant's, so I'm talking from a commercial litigant's perspective, is that they see litigation now more and more as a cost factor. It is a commercial aspect of how you resolve your disputes. Now, they are going to see whether this dispute is even worth attending to, or if we should just suffer that kind of an award or so and so. For example, just to give you an example, I recently in an arbitration where while as a respondent, our client won the arbitration, but costs were granted to the claimant. So the respondent was supposed to pay it. The costs were about 200,000 USD. But the claimant never called upon to pay. Respondent didn't pay. Now, for the claimant to go and seek enforcement of a 200,000 costs award, the cost for that will be much more. So these are the kind of practical considerations that litigants also have. Part of that is the paradigm of mediating or settling when the dispute starts. So it is a part of the litigant's mind. It is also a part of the lawyer's mind, and it does happen. We do, as a man, I would like to think that we all do advise clients where there is a possibility where perhaps the case is very evenly balanced, or whether it is even when it is completely imbalanced. So as a party which is completely weak, it should be upon me to say that, look, you may not succeed in the case. So it makes sense to consider settlement. And on the other hand, if you're too strong, then you should probably again do that to save your costs. But these are factors that are already there. They are there in the minds. What the Mediation Act does is it gives you a statutory nudge that is in the form of enforceability of a mediated settlement. Because otherwise, when I come outside of a judicial proceeding, which I'll come to, or a court proceeding, outside of that, a mediated settlement is just a contract, which would require its own set of the violation of which would require its own different proceedings. So it's redundant in that sense. From the judiciary's perspective, I think what we as the state also and we also must understand that there really should be a hierarchy of dispute resolution or judicial management from the court's perspective. I would say that the first would be, for example, constitutional matters, followed by criminal matters, and followed by other in rem important matters, and thereafter in personam matters, part of which would be commercial disputes. So it is actually, I would say, incumbent on the state to devise policies where more time, effort, resources are given to constitutional matters, criminal matters, which are more important in an objective sense, are more important. And if it is possible for devising a mechanism where inter-parties disputes are solved between the parties, that would reduce the burden on the courts, obviously, and that contributes to an overall contribution to justice in society. It's not just about reducing the court's burden or the judge's burden. It actually benefits us all in a broader sense, I would say. And therefore, the provision of Section 7 in this Act, as well as 89, I think it makes sense, because it's not just that the party's interest, the particular party's interest that the court is looking after. The court is looking after the state's interest and the public's interest. Part of that, therefore, is referring the parties to mediation. Now, they may or may not participate in that, and they may fail, but it is incumbent on the court to at least make that effort from a social perspective, that certain disputes are at least, attempted to be resolved by way of mediation and not through courts. So that is one. And last, of course, is the public. Obviously, the last stakeholder is the public. And among those, I think the concept of third-party rights, for example, which has already been covered in the Mediation Act, that you and I cannot decide to affect a third party. So that I think that makes sense. And also, this is also particularly because mediated settlements are going to become enforceable as if they were a decree of the court. So for that reason as well, two parties should not be able to decide how a third party is going to get affected, or the public at large is going to get affected. So I think none of these, and now coming back to what I was saying earlier about discussing mediation and settlements, that's something that is already a fact. Now, it actually happens even from the litigant side and the court side. Courts regularly advise parties or request parties that in the course of commercial proceedings specifically, that please take a minute, go back, I'm going to adjourn the matter, and you think about settling the matter, then come back and tell me what you have thought about. Parties sometimes settle, sometimes they don't settle. If they do settle, they file what they call a consent terms. Then the consent terms, which is much like a mediated settlement, becomes a part of the court's decision. So that's how the consent terms get the sanction of the court, and therefore, as a decree or order of the court, it becomes enforceable. So there is already a mechanism. But what happens is, these mechanisms kick in, or rather require parties to first initiate dispute adversarial proceedings. So I'll have to initiate the arbitration first, I'll have to initiate the suit first, or I'll have to file the IBC proceedings first. And only then the good sense will come into picture and prevail. The Mediation Act, through enforcement of mediated settlements, perhaps will nudge me to do that even before issuing the threat of legal proceedings. The current system will always also be available, but the Mediation Act, I think, gives us a statutory nudge to undertake that exercise even before thinking of starting the adversarial proceedings. So just to tie it up, I think the Mediation Act, therefore, is a policy measure, and the Act itself is a vehicle for policy. So in the debates whether the law is shaping the society or the society is shaping the law, I think here is a law that is trying to shape society, while society is also trying to shape the law. So it's happening in tandem. Both the things are going on. Now, so this was from a very broad kind of perspective, specifically as far as the Mediation Act is concerned. And I'm sure some of these things have already been discussed. I think it's probably good to see that IBC has not been part of the mediability aspect, because the fact is that even though IBC is not a debt recovery mechanism, it's still important that, as I said before, genuine cases for debt recovery should be filed before the IBC, but where there is a possibility for settlement, and there should be settlement. So now that will be governed by, I suppose, the Mediation Act will play a part in that as well. So that would make sense. Something that Tariq mentioned before is the government, right? And how the government deals with mediation. Government is a frequent litigant, I think one of the most frequent litigant in the country. So I feel like there should be something on the government's part in terms of policy that they should be required to attend to mediation or attempt mediation. One of the challenges that I have seen, that we have, I think many of us have seen happen from a government's perspective, whether it's a government-owned company or a state department or authority, the persons in charge are generally reluctant to sign away on any kind of settlement. However reasonable, rational the settlement may be, with the fear that, you know, that may subject them to some kind of scrutiny or inquiry or something like that. And that fear is not misplaced. I mean, I would say, irrational as it may be, the government may take such steps. So if there is a safety mechanism, for example, a waiver of liability for some government authority, any government authority that attempts and provides for a settlement or agrees to a settlement, that would encourage government authorities to actually attempt settlement in a more meaningful manner. And of course, that has to be counterbalanced with certain internal requirements from the government's end, because at the end of the day, absolutely yes, the government authorities are dealing with public funds, public interests, so there has to be some kind of sense to it as to at what point a government authority or official says, yes, okay, I'm okay to settle. So that is as far as settling is concerned. In a commercial context, I won't go too much into other kind of cases, but I think something we can borrow and something that partly already exists is stuff like plea bargaining, or I think it's still it's a part of settlement. It's a part of mediation, that I'm going to submit to a plea for a lesser penalty, or I'm going to, whether it's in commercial cases or other kind of cases where I'm going to submit to a penalty. I'm okay to submit to a penalty as long as you don't take an admission from me or there is no liability on my part. Those kind of things need to be infused in the government's working and government's dispute resolution policy. So the state, through the government, should lead by example, as the critical mass perhaps may be initiated by the government itself as a policy measure. It's not to say that the government should be taking it easy or giving up rights, but maybe they can take the first step and then we will also follow. Then I think one of the things that I see, again, this is a normative thing between Section 30 of the Arbitration Act and Section 17 of the Mediation Act. Section 17 of the Mediation Act, I think, provides that, just a second, that mediators will not act as arbitrators, if I understand correctly. Yeah. So, but the Arbitration Act in Section 30 provides that it is not incompatible with an arbitration agreement for an arbitrator to encourage settlement or participate in settlement. So, I mean, I can see the apprehension that where a mediator who's going to be privy to caucuses and discussions of a confidential nature, or everything, all the beans will be spilled before the mediator, etc. But I think from a normative perspective, it is not impossible for a mediator or an individual, a trained mediator. We have been focusing on the aspect of a very trained, advanced, skilled mediator. I think it is possible for a skilled mediator to keep aside the biases that are actually not developed biases while administering mediation. But even if they do, then you have the judicial mind to set those things aside and then go after and also arbitrate. So it's not impossible, but as it remains, I think there is some kind of a contradiction or inconsistency between the way the Mediation Act thinks about mediation arbitration and the way Arbitration Act thinks about arbitration mediation. So that's one thing. And lastly, I think as far as foreign mediated settlements are concerned, I understand that India has not ratified the convention. I think as far as foreign mediated settlements are concerned, there would be at least a scope for some genuine apprehensions. For example, if two foreign parties are entering into a mediation settlement, is essentially an agreement, and what makes it even more weighty is that it becomes enforceable. So that should not be a process through which Indian mandatory laws are circumvented. For example, FEMA regulations or any other such mandatory regulations, where say from a commercial perspective, two foreign parties enter into an agreement to deal with an Indian asset, an asset located in India. So these are, I think there are apprehensions, but none of those are impossible to be dealt with. So perhaps that is something that the state or the legislature can apply itself and consider the reservations perhaps that they may provide while signing or ratifying the Singapore Convention. But keeping all that aside, these are they would be outliers where parties try to circumvent, I would like to think. So where they are otherwise okay, they should be enforceable. So that is something the state can consider. I think that's about it. Yeah.
Thank you, Ritwik. I think you made a very important point in respect of how one of the largest litigants in the country, the government itself, can lead by example and incorporate mediation into their own dispute resolution practices. In the interest of time, I will just move into the Q&A round, so that, because I see that there are quite a few questions that have come from the audience. So I'll start with those. But before that, I just had one question for Mr. Tejas, and I'm going to take the privilege of asking the question myself before I go to the audience questions. You had mentioned what a model mediation clause might look like, and you said that it might be best to opt for institutional mediation as much as possible. But in your mind, would there be certain kinds of disputes which are best suited for mediation in an institutional scenario, whereas some which might perhaps just be better suited for ad hoc mediation?
No, I don't think so. There is any such distinction in terms of the nature of the dispute. It's a choice the parties have. And if the parties are entering into a mediation agreement after the dispute has arisen or at the time of entering the contract itself at the inception, they have an option to go either for institutional mediation or an ad hoc mediation. But the experience shows that institutions are always better equipped because they have the panel of mediators, as Tariq said. IAMC is one of the premier institutions who are training the mediators along with the experienced techniques of other arbitral and mediation institutions like SIMC, which is time tested and they have done it for years. So we have to call up that because there is no competition as such when it comes between all the institutions providing the mediation services. And the advantage is that you have the quality mediation, you have the rules, you don't have to reinvent the wheel and try to draft the mediation agreement itself. Sakshi mentioned about the model mediation clauses. Again, there are protocols in place. So if your mediation fails, that doesn't mean there is an end to the mediation process. You can always come back to mediation. I have had experiences where in an oil and gas joint venture agreements, the parties could not agree on a mediation. Then they went for arbitration. Then they came back on the liability issues for mediation. For quantum, they went back again for arbitration. So there are mix and matches of lot of options available to the parties, but it is always helpful to go for an institutional mediation, if any kind of mediation for that matter. In fact, matrimonial and other disputes are getting settled through court annex mediation centers. These are also mediation service providers, and they have their own rules and they have the trained mediators available. The problem is also we have to train the trainers, as Tariq was saying, is that we need to have the trained mediators, and then they should train the other. It should be a chain reaction, and that can only happen under the auspices of the institutions, and that is now recognized. In fact, the word institution or arbitral institution happens in find mentions in Arbitration Act, but the Mediation Act has gone one step ahead and recognized mediation service providers and also given the task which the mediation service provider will perform. And therefore, I personally feel that there has to be a push towards institutional mediation. And if we are having any arbitration or mediation, it has to be institutional. Only an ad hoc should be an exception. Institution should be the rule.
Thank you so much. There is a question that's been addressed to Professor Sakshi. when you say that it's going to be in a phased manner and eventually mediation becoming a default first step to dispute resolution, do you envision this defaultness of it as a mandate, or is it still a consensual decision between the parties as people become more comfortable with the idea of mediation?
So I did read this question, and I want to just quote here what Laila ma'am said. Ideally, in an ideal world, it should be absolutely voluntary to the extent that, people should come in forward and say, we want to try mediation. But because we don't live in that utopia, we can have a compulsory pre-litigation mediation where the minimum can be one session, and we make the system so robust that we're very confident that if parties come, we have a percentage like 88%. And the institutions in India right now also doing it.
Right.
So ideally, we should not have the compulsion, but maybe we require it just till we have the strength of that belief so much in the process.
Sure. So essentially, push parties into mediation till they're confident of the process, and then hopefully it'll become a voluntary thing by itself. Thank you. There's a question also for Mr. Tariq. How can judges in courtrooms be trained for mediation when they don't really have much of a role in the mediation session? I think the question may be speaking to the fact that you don't really have a judge sitting as a judge in a mediation. So really, how do you go about doing this training for judges?
Yeah. So what I meant by training for judges is not making them mediators. What I meant was that training them about the role of referral judge. Because ultimately it is the judge who's going to refer matters for mediation. And unless a judge understands the benefits of the process and understands how it is to be applicable, because a lot of times we have seen in court, even matters are referred. The judge has asked in open courts about what is the progress, what is happening in mediation. So they don't even know about this aspect of confidentiality, that they're not even supposed to discuss all this, and what is it that the order should say. Many times they say that mediation has failed. So, mediation never fails. It is incorrect to say like that. So in the order, it should be recorded that at this stage, parties could not settle, because later on parties may settle. So these are the things which are to be trained to the judges also. And I think that, unless they have confidence in the process, they will not be able to be the messenger of, mediation. Because a lot of High Court and Supreme Court retired judges who got trained with us, we saw that after the training, they are the ones who are actually becoming messenger of mediation, and they are doing the job for us. And coming from them, it's making, but unless they really expose themselves to the training, they would really not understand the potential that lies.
Sahana,
yeah.
I mean,
Yes,
I
please.
want to what Sakshi said and what
Yes,
Tariq
please.
said. To what Sakshi said, a simple example is matrimonial mediation. The law provides for conciliation. As a result, today we see that most matrimonial disputes are mediated. So a mention in the law really helps. Secondly, to what Tariq, the question that was asked to Tariq, referral, the judges need to understand human psychology. When parties stand before judges, they really trust the judges. The judge should be able to communicate to the parties that, I really believe in this process. Go and try it. As a mediator, I tell you, when the judge does that, 30% of the mediator's job is over. The trust is immediately built.
Thank you. I'm actually going to ask you a question that's in the Q&A section as well, Ms. Ollapally. So will the shortcomings in Section 12A of the Commercial Codes Act be addressed by the Mediation Act?
Well, to some extent it will, because confidentiality is protected under the under 12A, and mediation under 12A will be under the Mediation Act to some extent. So that way it protects. Yes.
So we have a couple of questions that speak of how lawyers can deal with situations where parties are not really willing to mediate. So maybe I'll direct this question to Mr. Ritwik. As a lawyer who would be advising clients and where perhaps you would want them to go to mediation, but there's resistance from the parties to go to something like this, and maybe they just want to skip ahead to litigation or arbitration. What kind of steps can lawyers take in their advice to clients to move to mediation first on a serious manner?
Yeah, I think that's a very important question. So, to simply put, the answer is we can give them a reality check. So, and the reality check is based on the legal application of what is going to happen. So, a fair and objective assessment of the legal situation, the rights of the parties and the obligations of the parties, and also what they may be required to pay up or they may suffer. This is something that a lawyer can explain to, of course, this is between us and the client, and there's also between us and the opposite party. So between us and the client, it is important to explain to the client, especially where there is resistance on mediation. Now, it's not. Let me be clear. It's not that we should be pushing or shoving mediation down the clients in any sense. If the client is not, if it's a reasoned call, it's not correct to enforce mediation or settlement or negotiation on the client. But what we can do is explain what will happen in this case, how long, and that includes non-legal factors as well. The legal aspect is if you may or may not succeed. The other is how long this may take, how much this will cost, so on and so forth. So that is a complete assessment that a lawyer can provide to their client is one thing. The other is when you're dealing with the opposite party also, you should be perhaps, as a lawyer, you may be able to communicate to the other side that it doesn't make sense even for you to continue with this dispute. And if this includes cases where your client's case is stronger. So therefore, this is all in the interest of what perhaps I would say litigation economy. To be economical in terms of your dispute and even explain to the other side. And as a matter of fact, at this very moment, I'm dealing with a situation like that, where we are trying to explain to the other side as well that it doesn't make sense for you because it will not work out well, definitely not for you, but at worst, this will be a Pyrrhic victory in the sense that both the parties will not succeed or gain any realistic advantage from the conclusion of the proceedings. So I think, but I mean, at the end of the day, of course, the parties also have to think about this, that it's whether it is important for them to litigate and to prove their point or get done with it and be commercially sensible. So
thank you. So I'm just going to open this question to anyone who wants to take it, actually, because it deals more with questions of the kind of training that mediators can get, the kind of training that parties can get in mediation. And there were questions asking for the difference between these two, mediator training and mediation training. So anyone who wants to jump in with an answer to that.
I think Tariq would be the best.
I think in my view is that when we did a training for mediators, I think more about, difference like what is a conflict and what is a dispute, getting into the psychology of things, how to de-escalate tension between parties, how to break an impasse, what kind of disputes are fit for mediation, what kind of disputes are not. What is the process of mediation? How do you start a mediation? How do you gain the trust of the parties? The role plays really help you quite a lot. Understand, how you have to behave in a setting. How should your body language be? The role of body language is very important. I never knew all these things until I myself got trained. I've done like 4 trainings now. And I think every time I do a training, I realize that I need to learn a lot more. So, mediation training is completely different from what you do in a court or in an arbitration in an adversarial setup. So I think training for a mediator really changes the way you look at a dispute. You look at the why of things rather than what it is, because when a dispute goes to the court, you can't go behind the dispute. You just apply the law on that and pass a judgment. You don't really want to focus on the interest of the parties or what the position they have taken and moving them. Nobody really spends time on, maintaining the relationship or telling about the collaboration. There's only a competition, A versus B. So mediation, I think, teaches you that, there can be a solution which works best for both, and both can be the winners. And how this training tells you how relationships can be maintained. Now, the other training is mediation advocacy training, which we did with Laila ma'am, and I think she'll also give her comments on that. This is a training for lawyers, because now there will be a need for lawyers also to represent clients in a mediation, because it's not always parties directly coming. There's also lawyer involved. So how lawyers should negotiate, because ultimately mediation is all about assisted negotiation. It's nothing but assisted negotiation. So, the art of negotiation, I think from lawyers' perspective, that is the key, how mediation, in a mediation, lawyers and advocates should behave. And I'm sure Tejas sir will also be able to add how, as a leading practitioner, because I'm sure they have been doing with a lot of commercial high value dispute, he negotiates with the other side, and Laila ma'am will be able to tell you a lot more about it.
Thank you. Would you like to respond to?
Yeah, I can add to what.
Sure.
So recently, we at CAMP, we did a training for training of trainers in the Supreme Court. It was a 2-day training. And why we thought it was important, mediation training is experiential. The skill of mediation is like a dance form, it's like an art form. And it's not theory that works. It is the experiential learning. So 2 days we spent with trainers in the country on training of trainers. We spent a day in the National Law School on conflict competence for corporates. Very many of us deal with conflict without really understanding what is conflict. How competent are we to deal with conflict? Similarly, as Tariq mentioned, for advocates in mediation perform a very different role to what they do in an adversarial setting. In an adversarial setting, advocates are gladiators. Whereas in mediation, they are negotiation coaches. They, in the spirit of educating the parties, both parties, they bring in information into the room. The advocates are wearing a different hat. They need to understand that role for the success of mediation.
Thank you. I'm just going to jump in with a question of my own here, since we are speaking of mediation training. I'm actually referring back to something that Mr. Tariq and Ms. Ollapally had mentioned when you were first giving us your thoughts on the Act. There was a reference to how mediation centers should have the required technology, and we also know that online dispute resolution is something that's really coming up and is being encouraged. But Ms. Ollapally had also mentioned how mediation is essentially a form of negotiation. It takes off where negotiation leaves off. My question really touches upon the fact that when you're speaking of negotiation, there is a lot to be said in being in physical proximity of the parties. But when it comes to online dispute resolution, of course, that's not necessarily possible. So would the kind of training that you might impart, keeping in mind ODR, or even the fact that regular mediations might happen, let's say, because people are in different parts of the world, in a post-COVID world, we're just using technology a lot more. How might the kind of training that you provide, or the kind of things that parties and mediators might have to keep in mind in order to sort of seamlessly actually facilitate the mediation, how would this change today?
Tariq, you want to go first?
Ma'am, please go ahead.
Okay. So what is mediation? It is an interest-based process. By interest, we mean what do parties want? So a mediator, skilled mediator, will always examine what the parties want. Recently, I was doing a matrimonial mediation, and I was doing a shareholder, it was a franchise dispute. And the commercial parties, I thought the matrimonial parties will need physical and the commercial will need online. It flipped. It was the matrimonial parties who wanted the safety of online. And the commercial parties wanted physical. They had a lot of documents. They wanted to share the documents. So the mediator discerns which is the best process. And today's hybrid. When I spoke about the 60 parties mediation, it was a labor dispute. Initially, we had to make it physical. Then they got comfortable with online. So the mediator weaves in and out depending on what the parties want. But what is important is mediator should know how to use technology and do what is required.
Thank you so much. We are running quite short of time, so perhaps I'll take closing remarks from all of you with respect to anything that everyone else has said. There are a lot of questions that I can see, but we really don't have the time to answer all of them. So perhaps I can start with Professor Sakshi, your closing remarks today.
I want to say thank you to NLS Bangalore and NLSIU Bangalore and all the panelists. I've learned so much today. And there's one question which I read, which I think is a very common question for students generally across law colleges. And I just want to address that, which is about the difference between these mediation competitions and real life mediations. And, students are discouraged so much if they don't perform well in these competitions. So that's why I want to highlight this, that there are three kind of barriers. And Laila ma'am can obviously add on this. She's judged so many competitions. They're cognitive, legal, and factual barriers. Factual barriers and legal we can play in a simulated environment. But cognitive barriers, which are there in real life mediations, can never take place in a competition situation, in a simulation situation. So no matter how well you do in a classroom, in a simulation situation, the first time you see a real life mediation, you'll get a shock, which is similar to your experience if you're a very good mooter and the first time you stand in front of a real court. So because of that, I want to just advise everyone that if you are interested in mediation, like ma'am said, it's an experiential based skill. Please try to, it's a confidential process. That's why it's difficult. But if you're suppose interning with Sam or someone, just try to make efforts to be in that mediation room, so that you can learn from what actually happens really. So that's just my little advice for students who are watching today. Thank you again. Thank you, everyone.
Thank you, Professor. Perhaps we can have Mr. Karia's closing remarks on this as well.
Sure, it was very interesting discussion, and I thoroughly enjoyed it. There were a couple of questions which I just wanted to quickly touch upon. One was that how we can help the juniors to start the career in mediation and arbitration. So my suggestion would be that all of us should get trained. So there are a lot of courses. For example, Chartered Institute of Arbitrator is offering a lot of courses where you get accredited. There are courses in India by various institutions. SIMC is offering a lot of courses. So moment you are trained, you can build your profile as an arbitrator or a mediator or a practitioner of arbitrator and mediator. You can also work with the law firms or the lawyers who are specializing in this field. And moment you become a specialist or a trained mediators, you can co-mediate with the experienced mediators. And because of confidentiality, you'll have to be part of the process. Either you're interning or you're working in a law firm which is offering this kind of opportunities, or you are appointed by the institution who can make you as a co-mediator or put on a reserve panel, and then slowly you grow into this entire profession. There was one more question pointed towards me, which was with regard to how the corporate sector would change. Now, there's a lot of pressure on the in-house counsels to save time and cost in dispute resolution, because they're answerable to their management and they need to reduce the legal spend on the disputes, and that's not productive use of their time. So mediation, and with this act, it really helps them another option to formally resolve the dispute in a very effective way, which will really take away a lot of burden on them to spend on the litigation or arbitration. So I think that the corporate sector is going to really get benefited and will be very happy with the more use of mediation process for resolving their dispute, because you already mentioned that there is an increase in demand for dispute resolution, and mediation can offer a very good alternative. In fact, it should be a parallel and not an alternative to any arbitration or litigation. It should be treated as a main form of dispute resolution before even you can think of arbitration or litigation.
Thank you, sir. Ritwik, maybe you can give your closing remarks.
Yeah. So firstly, of course, thank you to NLS and the team to have set this up and invited me, and also to the panelists for taking out the time. So to be honest, it's great to learn from these esteemed panelists and their insights from practice, from handling institutions, from contributing really to policy. So very important inputs that we have all got to hear today. So it's very enriching. And of course, how the Mediation Act itself will play out is something we'll have to see. But it's a good step. I think it's a good step. Hopefully, the courts will mold it in a way that actually benefits and furthers the view. I completely agree with Tejas sir that it should be mediation is not it's not an alternative dispute resolution mechanism. It should be a primary dispute resolution mechanism. So hopefully we'll walk there and reach there someday. So yeah, thanks.
Thank you. Mr. Tariq.
Thank you very much for giving me this opportunity to be on the same panel with the likes of Mr. Tejas Karia, Ms. Laila Ollapally. They're very senior people, and I'm really happy to see their cause towards mediation. And they've spent so much time on this discussion. So I think it's commendable, and it's really I appreciate this quite a lot. And my plea to the students who are watching this, and especially the universities, is that we should now move from the culture of moot courts and A versus B. We need to start teaching our students, and we need to start inculcating the way of collaboration while going forward, rather than competing and looking at things like one has to be a winner. So why one has to lose to make the other person win? We need to start inculcating new not even a competition, exercise, and something which actually will tell students that, look, there is a way where both can win. So as future leaders, advocates, problem solvers, peacemakers, you all have the power to shape the world that we are living in. And one of the ways you can do that by contributing to a more harmonious and a just society is by doing these trainings, by championing the cause of mediation, and understand that it is not just a process, but it is also a mindset that will foster a lot of collaboration and understanding, and resolve conflicts in the society and make it a better place to live. So this is my plea. Please do these trainings and see what it is and be the leaders of tomorrow.
Thank you. And last but not the least, can I have Ms. Ollapally's closing remarks, please?
As I started off saying, when law schools think seriously about a concept, it happens. That's where creative thinking begins. This is a good legislation. It's a big step. Mediation, collaboration has been brought shoulder to shoulder with the adversarial. I hope and pray it far moves forward than every other process. And as I mediate, the more cases I mediate, the more I realize that the potential for this process is immense. And that, I'm sure, is the experience of all those who have engaged in mediation. Look at creative ways. And this is my appeal to the students. Creative ways of making decision-making possible in all situations, whether it's multi-party or whether it is the government or domains. How can we make creatively decision-making possible for all these sectors? And I like what Ritwik mentioned. It is about seeing the justice that exists in mediation. It's a different kind of justice. The justice in mediation is about about the human being, connecting to the human being, understanding what that being is comfortable with. As lawyers, as students of law, let's focus on the human being.
Thank you so much to our panelists for taking out your valuable time to have this discussion. I'm absolutely certain that this was both insightful and very, very useful to everyone who's been watching. I'll just quickly hand over to the ADR Committee of Analysts for their thanks.
Hello, thank you so much, Professor Sana. And I think ma'am has summarized it brilliantly. It was an extremely enlightening session. As a student, I can tell you that I've learned a lot today. I'm glad that the panel was extremely diverse today, and I will thank my team, Aditya, Karthik, Adamay, for that, for inviting such diverse set of panelists. Whenever Tejas sir and Ritwik sir would bring in, their practical insights into practice, into litigation, etc. Sakshi ma'am would then bring in like the theory, and I was really excited about that. First movers, a sort of disadvantage that you exercise in mediation. That is something that comes out in theory and is important that we learned about it today. Laila ma'am, of course, gave her insight into as a practicing mediator. The suggestion that stood out to me was the opt-out model. I think that is something I'm going to read up more on, research more, and perhaps write on it. And of course, we have Tariq sir, who's been great. He's been a great help. And the aspect and like the perspective that he gives on institutional mediation is, I think, very valuable for us today, especially when this act is taking us towards mediation. One thing that I would like to quickly flag is that this session was important for us. We thought that we'll do this kind of panel discussion because the mediation bill, like I think the 6-7 of us understand how important it is, but I don't think so it was very well reflected out in the public, whether it be the academia, whether it be general, right? Today, even if I Google up some sort of commentary on the Mediation Act, the max I can find is a bar and bench article that has been written by Laila ma'am herself. So that is when we thought that, like we need more discussion, we need more academic discussion, and perhaps it was passed in a rushed manner. It was passed when the 3 criminal bills were also being passed. Therefore, it lost the view of, let's say, students as well. Nobody was talking about the Mediation Act. And on a lighter note, I think in law schools, I can tell about NLS, arbitration as one form of ADR is glorified a lot. So everybody wants to do arbitration internships, they want to do arbitration courses, electives, etc., just on arbitration. Mediation is a form of thing that is not well read, not well written, especially, and I'm purely speaking from a law school perspective as to how students perceive it. But I'm glad that both this act as well as this panel discussion is going to go into history as one of the things that we've done to promote mediation, to promote a culture of mediation. I will take your liberty to record this session, to put it on YouTube so that it's accessible to everyone like for a long time, because this Mediation Act is going to exist for a long time. I would also take the opportunity to thank a couple of first years from law school, Himang and Aruna, who have been taking down detailed verbatim of whatever you were speaking. They're going to put it down on a report. We'll circulate that report, and after hearing your comments, we're going to publish that as well and try to circulate it as much as possible. So I think that is it. I would quickly thank each one of you individually, Tejas sir, Tariq sir, Ritwik sir, Ms. Ollapally and Sakshi ma'am. You've been extremely great. We've learned a lot. I think NLS has had some sort of connection with all of you from a long time. I have personally had a chance to meet Tariq sir and Tejas sir last year. The NMC, which we organized, which is our it is now South Asia's biggest competition on negotiation, mediation, and client counseling. So we are shifting away from arbitration, promoting these alternate modes of dispute resolution in that true sense. I was in the morning only going through some emails, and I found that Ms. Ollapally has been associated to this competition back since 2014. Like long back, I even entered this law school. So I'm glad that now you're back here. I also read that CAMP and NLS did a sort of a collaborative endeavor this time in October when we were away for vacations. And I think this just is enlightening for me as a student that ADR is going, my college is doing something, and that we can do it ahead. On a lighter note, I will also put forward my interest, put forward a request for doing some kind of collaborative research work. The ADR board, honestly, today we have a committee of roughly 70 students, and these 70 students, let me tell you, are extremely passionate about moving ahead in ADR and promoting the culture. I'm I'm very today grateful sitting with all of you who are associated with institutions like CAMP, Shardula Merchant, Khaitan, IAMC, who are known to be the torchbearers for ADR, and they have grown and they're responsible for ADR in the country and are still promoting it. So I'm opening my hands if in the future there is any opportunity for us to indulge in any sort of research endeavor. On top of my head today, I can think of some kind of a mediation primer of this very act, because the problem that we are constantly dealing with is the opt-in, opt-out, how to promote parties, because the act has, after all, made it voluntary, right? But the consensus that I got from the panel is that we must still promote. How do we promote? What can I do? I can perhaps simplify the act for students. I can simplify the act for business people who are ultimately going to be parties to this. We can make sort of a handbook for it, and I think ideas can flow all in all. So yeah, if in the future any of these institutions we get a chance to work along with, we'll be the happiest to collaborate, to research with you, provide whatever expertise and skill that we have, limited skill that we have to you, and contribute to whatever we can. So on that note, once again, a big thank you to all of you for taking out time on this busy Sunday afternoon. I think all of us are excited about the World Cup as well, as Tejas sir had flagged at the very beginning. So we'll not keep you waiting. I will, of course, thanks Professor Sahana Ramesh for taking out her time and moderating this session. It was lovely. I would also thank NLS administration and IT team for setting up this and doing all the things. I know last night there was some tussle about the links, but Vinod sir, who's the IT department, who handles IT department here, was there on call. And he sorted it out. So yes, thank you once again. It was lovely meeting all of you.
Thank you everyone. Thank you very much.
Thank you everybody.
Yeah, thank you.